You know something is wrong when an American Affidavit of Probable Cause. Part 4. Moving on. The titles of Nobility Amendment, 1810 to 1819. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall without the consent of Congress accept and retain any present, pension, office of emolument, of any kind whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them, or either of them. It took almost 9 years, but on the 12th of March, 1819, Virginia became the 13th and final state required to ratify this amendment to the Constitution for the United States of America, not to be confused with the much later look-alike, sound-alike, corporate Constitution of the United States of America. The titles of Nobility Amendment added a strict, specific, and enforceable penalty for violations of the already existing constitutional prohibition in Article 1, Section 9, Clause E, loss of citizenship and inability to hold public office. So what are all these district courts and state courts inhabited by black-robed, bar-membered judges and attorneys sporting the title Esquire? They are private courts operated in foreign jurisdictions by undeclared foreign agents. The American Bar Association has a treaty allowing it to function on American soil, which it has grossly abused. What appears to be state statutes are issued under private copyright. Public documents are all public domain and cannot be copyrighted. The take-home news for American state citizens is that no member of the Bar Association can occupy any public office associated with you, nor your state on the land, nor the continental United States in general. If a Bar Association member is associated with any action pretending or having actual impact upon you or the land jurisdiction on the continental United States, that action is null and void. None of the courts you commonly see rampaging around issuing charges and handing out orders have jurisdiction over your person or your property. No act of any version of Congress or state legislature tainted by members of the Bar Association can be applied to you. Who do bar members work for? The Bar Association members can work for the federal United States and for the Washington, D.C. municipality and the United Nations city-state, and all these foreign governments have created franchises that they operate under your given name. They regularly attack these franchises and make false claims that seem to be addressed to you, a purposeful deceit called personage. But in fact, by maxim of law, those who create franchises are responsible for all debts and upkeep costs of those franchises. Note the crimes involved. Personage, the crime of knowingly misrepresenting a living man or woman as a legal fiction, some form of corporation such as a trust, public utility, or foundation. For example, knowingly miscategorizing a living woman named Elizabeth Arden as if she were a corporate design company known as Elizabeth Arden, Inc. is a crime of personage. Barratry, yes, named after the Bar Association for good reason. The crime of knowingly bringing false claims and charges based on personage in order to use foreign statutory law against living people. These two crimes are routinely practiced by members of the Bar Associations worldwide to inflict unjust punishments, defraud people of property, and to raise money for themselves and the banks they work for. The American Bar Association has violated their corporate charters, the Smith Act, and the Taft-Hartley Act with impunity. Fearing retribution, Nobody has had the guts enough to take them on and expose their criminality. Where the big confusion starts. There are living people born on the land of the 50 States United who are civilian inhabitants of the organic states known to be birthright citizens of the continental United States. People who are owed all the guarantees of the Constitution, a republican form of government, and full enjoyment of their natural rights. There are living people who were either born in federal territories or who are defined as federal United States citizens by default, contract, or treaty, who operate under the international jurisdiction of the sea as part of a democracy. They have only civil rights, which are granted or taken away by members of Congress. There are legal fiction persons, millions of them named after living American state citizens, all routinely called U.S. citizens or United States citizens. We have the actual organic states, and we have the states and states that only exist on paper. We have actual people who are citizens or citizens, and we have all sorts of legal fiction entities that are being passed off as citizens, and you asleep at the wheel. Who is responsible? It's a long list. The Holy See and the Vatican and all the popes since 1845, the British monarchs since 1845, the Crown Commercial Conglomerate since 1845, the Crown Temple and Bar Associations since 1845, the U.S. Army since 1863, the Joint Chiefs of Staff since 1944, the United Nations and the Secretary General since 1944, the United Nations since 1943, the Federal Reserve Association since 1911, the Federal Reserve System since 1913, the World Bank and International Bank of Reconstructions and Development since 1930 international and 1933 domestic, the International Monetary Fund since 1944, the Vatican Bank since 1930, the Bank of International Settlement since 1944, the United States of America, Inc. since 1868, the United States, Inc. since 1944, the Federal Reserve since 2011, the United States of America, Inc. since 2013, the members of the United States Congress since 1861, the members of the United States Congress since 1933, the Congress of the United States of America since 1868, and all presidents since Lincoln, except Garfield and Kennedy. Note: legalese caused the confusion. Only people can be American state citizens. Living people have appellations, not names. Only things have names. Also, living people have autographs. Only corporate officers have signatures. Also, in law, people are either described as, for example, John Quincy of the House of Adams, or denoted by the use of all small letters, as in John Quincy Adams. This doesn't agree with what you've been taught to think and do and say, but it is of vital importance to know. In legal parlance, the style in which a name is written tells lawyers what it is. Legal styles of names. A name, appellation, of a living man or woman is written in all small letters. John Quincy Adams. A name written in all capital letters can only be one of two things: a corporation of some kind, or a dead man's estate. Purchase a hard copy of this book at Amazon.com or download a free PDF copy at states.americanstatenationals.org. Click on the red Education tab at the top right of the page. You will find it here.